It is dramatic to see a grandmother handcuffed in a courtroom and then led out, but what the jury really said was that not guilty on the top count. It took them just over 2 hours to come back with not guilty of aggravated manslaughter. She would have faced up to 30 years behind bars if she had been found guilty of that. What she did get found guilty of was a misdemeanor. Second-degree misdemeanor of leaving a child in a car. When you look at the Florida statute, that's under the traffic laws, like where you would have someone who maybe drank and drove or didn't wear a seatbelt. And from what I can gather from the statute, the max penalty, and we'll get further clarification from the attorneys, we'll see if they'll talk to us after this, but up to 60 days behind bars would be the amount that she could get. But you see they're remanded into custody. We see that reaction from the family, from the parents of this little girl who was left in that car and died in that extreme heat. Let's bring into the discussion those who are standing by just to react to this verdict, this very emotional trial for everyone who's been watching and everyone who's touched by it. We have criminal defense attorney Sam Bassett, who is joining us, and also in studio we have field reporter Cody Thomas, who's with us. Let's bring in criminal defense attorney Sam Bassett, who's with us. Sam, what do you think about this verdict and the fact that, to Cody's point, this jury did not hear about that pond incident where her other grandchild died?
Well, I think if they had heard about the other incident, it might have made a difference. But despite that, this is a huge victory for the defense, in my opinion, to avoid a felony conviction. And I think the jury paid close attention to the jury instructions, which talked about no conscious intent to harm, not gross or flagrant negligence. So I think that this was a verdict where the jury read the instructions carefully and decided that the higher charge simply was not proven.
Sam, let me pick your brain a little more, because we had sort of a dramatic moment in there of the judge revoking her bond, remanding her. She's handcuffed. If, in fact, this is a second-degree misdemeanor under traffic laws in Florida and it's up to 60 days, do you think he was sending a message with that move, or is that typical for a case like this?
Absolutely, he's sending a message. Most of the time in a misdemeanor sentencing, a judge wouldn't consider keeping the person in jail pending sentencing. So I think the judge, for whatever reason, maybe he disagreed with the verdict, maybe he wanted the community to understand that when something like this happens to a child, there are going to be serious consequences. And it's hard to say why he did what he did, but I would imagine he wanted the community to see her put into custody immediately after being found guilty.
I want to add a bit of information, because we are trying to learn about how long it may be, how much she may face. There is a possibility that because of the great bodily injury, that this could be something that's punishable of up to 5 years. We will see. We'll get you the clarification on that. And when we're discussing what could have come in, what may impact sentencing going forward, I want to take a look at an order that the judge made on the prior act, because typically, Sam, that's something that could aggravate sentencing, could be an aggravator. The court could find, let's say it's this third-degree felony that could be punishable up to 5 years. The judge could take into consideration something that was perhaps not taken into consideration before. But in looking back at the court file on this case, we have this in an order from this same judge on that pond incident, where the court actually found that the defendant was asleep when her husband was the awake person taking care of Ezra. That was the brother of the victim in this case. And that the grandfather left without waking her up and didn't pass, in a way, that responsibility to her because she was asleep. So the court found that the state failed to prove by clear and convincing evidence that Tracy Nix was the party responsible for the incident and death of the 16-month-old infant. With that strong language, do you think the court is going to take into consideration or perhaps sentence her higher because of that other incident? Or is that, from what His Honor has said in the order, something that he's not going to consider at all?
I think he'll have to consider it. I think even though it's mitigated by the fact that somebody else apparently took over, quote unquote, for the care of the child, the primary responsibility was with Tracy Nix. And there was apparently some split responsibility there. But at sentencing, everything comes in. I mean, not everything, but almost everything comes in at sentencing. where we have a much narrower admissibility standard for guilt innocence, the sentencing hearing is more wide open. So I do believe he'll consider that incident in assessing the sentence.
All right, we are going to take a break, but we're going to keep talking about this case. In particular, there were some things that happened during deliberations that the jury didn't even know about it. 3 experts on the stand and what they had to say about what could have impacted this grandmother's forgetfulness. More of this Tracy Nix case after this. And what happened during that time was the jury came back with a verdict before Dr. Diamond could even put all of his testimony on the record. But we wanted you to hear it because it's so important to this case and likely will be important to an appeal. We did get word from on the ground there in Polk County, Florida, from the defense attorney confirming to Court TV that what she was found guilty of, that leaving a child in a car for more than 15 minutes is a 3rd-degree felony because of that great bodily injury that occurred. And it's up to 5 years that Tracy Nix, who is 67 years old, is facing once she goes to sentencing. Let's bring back in our guest to discuss this case. Criminal defense attorney Sam Bassett is with us remotely, and field reporter Cody Thomas is here in studio with us as well, just reacting to this case. Sam Bassett, let's talk about Dr. Diamond on the stand, not in front of the jury. They didn't hear him. Do you think if they knew more about forgotten baby syndrome and what he didn't get to, but I know because I'm familiar with his work, that he says when a person is out of their normal routine, like this grandmother who didn't typically take care of her child, that's when these forgetful things happen?
Yeah, I think that this is another example of maybe guilt innocence evidence versus sentencing evidence. I think under the rules of evidence 702, the judge has a gatekeeping function on whether or not experts can testify, both in terms of the reliability of the evidence and whether or not it will help the finder of fact, in this case the jury, reach a decision if there's relevant use for the testimony. I think this judge decided no, that there wasn't enough to assist the jury in finding guilt or innocence, and he kept it out. So the defense did what they had to do, is to put his testimony on the record as much as they could to establish the record for an appeal on that issue.
Hey, Sam, final question for you. Do you think she should have taken the stand?
Oh, that's a real tough one. Usually in most criminal trials, the defendants do not take the stand, in my experience, and that's usually a wise judgment. In this case, I think it was probably the smart thing to do, especially in light of what we've seen the jury conclude with the verdict. If she takes the stand, she runs the huge risk of what we call opening the door to the prior incident. If she were to make some sort of global statement that I always take good care of children or something like that, then bam, all of a sudden the jury gets to hear about the prior death. So I think it was the wise choice that she not testify.
That is a tough call. And Sam, I like that you brought out that she could have opened the door and it would have been difficult to stay on task, but you kind of wish the jury got to hear her explanation of what happened. But clearly they did not think that it was aggravated manslaughter, so this is a win of sorts for this defense. Sam Bassett and Cody Thomas, thank you for weighing in on that. Let's bring in criminal defense attorney Sam Bassett, who is standing by watching this Ponzi scheme murder trial with us. Sam, we're getting into where the insulin came from. The prosecution says that's the insulin she used to kill her husband. What's standing out to you about this neighbor's testimony?
Well, one of the interesting things about the context was that she was kind of coming up with this story about having cancer issues, and who she went and saw, her blood sugar was 280. It's kind of painting a picture that the defendant seems to be telling stories and not bashful about doing so, and using subterfuge to get some insulin, and also the expertise that the defendant has with regard to medical issues. I think the state's doing a good job of kind of laying that groundwork as one of the big pieces of their circumstantial case.
Yeah, you would think a pharmacist wouldn't be using a neighbor to get insulin from a neighbor's child. But let me ask you about the federal case. She's already serving her 11-year prison sentence in federal custody for the Ponzi scheme. She pleaded guilty to those charges. Do you think that that hurts or helps the case against her, because she could say, I already pleaded guilty to that. I wasn't trying to cover things up, even though my husband died before she pleaded guilty, but that she was okay with taking the rap for that. She wouldn't have wanted to kill her husband over it.
Well, it definitely hurts overall, but the defense is trying to diffuse that by saying that's a separate issue. And it's kind of a trial within a trial as to whether or not these two folks were jointly carrying out this Ponzi scheme, or was it her doing it and he was ignorant of the issue as the state portrays. So there will be, like I said, probably a little trial within the trial regarding that Ponzi scheme.
Yeah, you're right. Unfortunately, putting the victim, Michael Cochran, on trial as they do so. Sam Bassett, thank you so much for your analysis this entire hour. We do have to get to a break, but coming up, we have more testimony in the Ponzi scheme murder trial for Natalie Cochran. Plus, Court TV's Kelly Craft joins us live for an update inside of the courtroom there in West Virginia.